All right. I am really clear on the expectations. I understand I am standing between you and, of course, your beverage of choice, which would be Coke on the rocks, right? Yeah. All right. With that being said, good afternoon. It's absolutely fantastic to be at year 2 of Day with DISA. I think for those that remember or recall last year, Nina and I did a presentation, and we built it or focused it around the 3B principle. And I think if you recall correctly, it was about being bright, being brief, and then being gone. Well, as a result of that, and consistent with that approach, this year we're going to bring you information that you can apply to your employee screening requirements, and we want you to be able to use that information at the close of this particular session. So with that being said, we have a new principle this year that we're going to operate around in terms of this session. And that principle is what is simple is understood, what's understood gets executed. So let me say that again. What's simple is understood, what's understood gets executed. So when you think about that value perspective, today, Nina and I, we endeavor or hope to take the complexity of managing your dynamic employee screening program, and we hope to provide you tangible examples and a process or methodology that you can apply moving forward for your program. So as it relates to the agenda, this is what we're going to cover today. We're going to take a look at state laws, and I'm sure based on Faye's last session and some other sessions, you understand completely that that's the moving target. We're going to look at the impact of marijuana. As you're all aware, this is a wide-ranging topic, and we're going to focus on the impact of marijuana as we move forward, not only for the end of 2019, but as we move into 2020 and beyond. We're going to look at the future of workplace drug testing. We're also going to look at program innovation. But most importantly, and finally, I think what you all came for, is we're going to look specifically at how we can help in terms of helping you draft the appropriate policy, or in this particular case, the perfect policy or policies. So let's get underway. The first thing, and I thought about the title, the perfect policy. And so as I thought about that title, I thought about the legal community. And so the first thing I wanted to acknowledge for the legal members in the room, the title is a bit of puffery. So when we talk about that bit of puffery, or what some lawyers may potentially allege, a bit of false advertising, there is no such thing as a perfect policy. Let me say that again. There is no such thing as a perfect policy. As you think about all companies and you think about how you differ in your employee base and what you do, you know it's extremely difficult to create a policy. When you think about the 480 bills that were passed from a legislative standpoint in 2019 alone, it is just difficult keeping up with those particular changes. There's no template that we can give you to say, hey, just follow this particular magic template. When you think about the policies, long gone are the days that you can write one policy and it covers your entire organizational base for 1 year or 2 years, let alone 5 to 10 years. For instance, when you think about it, think about FMCSA. Every single client covered by FMCSA, you need to update your policies for 2020 based on changes. So ask yourself, are you prepared? Have you done that? When you think about the aspects of oral fluids, there are some changes that will be, they were recently announced as early as of today. I think there'll be a more official announcement coming out tomorrow. And as it relates to those oral fluid testing obligations, as it relates to your policy, have you made the appropriate adjustments? If not, you're already behind. Unfortunately, or ultimately, when you think about the investment in terms of a company's policy, I want you to think about that your policy is part of your risk mitigation strategy. So when we talk about that risk mitigation strategy, it's important to keep those particular policies up to date. Not only do they protect you, but they protect your employee base. In today's presentation, of course, we're going to review the different types of laws. And we're going to help you plan as it relates to 2019 and 2020, of course. When you look at the different factors that influence laws, you not only think about your drug testing policy, but you also think about the fact that there's not a one-size-fits-all. And that's only because your workplaces are so varied and so different. I'd ask you to think about this when you think about the laws, the rules, the processes, the policies, and the procedures. Imagine, if you can, a room full of artists, right? And when you think about these artists, some artists, as they look at a still life and are asked to replicate it, some artists are going to use watercolors, some artists are going to use charcoal, and of course, some artists are going to use other means such as oils. Some will try to make an exact replica, and of course, I submit to you, the Picassos in the group, they're going to interpret things very differently. But what about the artists such as myself? I'm going to take it and I'm going to throw the paint on the canvas, and what comes up comes out, and I'm going to call that still life, right? The thing that's challenging about that is that all of the interpretations are correct. So when you think about the laws, all of the interpretations are correct. None are wrong, but they're all just very different. So state drug testing laws we look at in terms of that particular approach. So the good news for you today is that as it relates to state drug testing laws, they're kind of organized in a way that brings organization to this chaos. So as you look at the mandatory and voluntary laws, 17 states, 3 cities, and 1 territory, and 15 states have different mandatory and voluntary laws that your employee base should be aligned around. When you think about the case law, 12 states and some with multiple cases. You think about workers' compensation and unemployment laws, and you think about industry-specific laws. But most importantly, you think about medical and recreational marijuana, and that's what we're here to discuss today. So with that being said, I think it's an appropriate segue to turn the floor over to Nina, as she's going to cover the impact of medical and recreational marijuana and the development of policies as it relates to medical and recreational marijuana.
Hi, everybody. If you were in the earlier session, there's a whole lot of repetition. I'm warning you now, if you got up and discreetly walked out, I would be fine with it. As Frank said, again, if you've ever heard me talk, I'm not a lawyer. And so to Frank's point, right, let's try and make this simple. But if there are 480 bills that were proposed in 2019, chances are there's something you got to be paying attention to if you're doing business in the United States, right? And they run the gamut of these things. And it is, when you look at the different laws, this thing seems awfully loud. When you look at the different laws in the different states, they address all sorts of different things. So some are very, very specific, and they say things like, you must have this drug in this panel using this methodology. Others don't even mention drug testing. They say, you like to have a drug-free workplace, this is what you have to do. It doesn't specify drug testing. So you really have to have a handle on it. Now, if you're doing it wrong in your state, are you going to get sued? What's the probability? Is somebody going to know that, you were supposed to test at 50 nanograms, but you didn't? Maybe not, right? I think the biggest mistake as we look at all of these progressing laws and laws that apply in your workplace is there is a broad assumption by employers that, and we're here with DISA, right? So I'm going to say for DISA, that DISA's got it. They know. They got it. Don't worry about it, right? Tennessee, voluntary law passed this year. If you comply with the voluntary law in Tennessee, then a valid prescription means a drug that was prescribed and it is 6 months or newer. So if DISA is your MRO, I'm assuming they got that, right? Well, no, they don't have that. They don't have your policy verbatim. They don't know if you've made changes to your policy. They don't know if you comply or choose not to comply with that voluntary. And it isn't DISA specific, it's any employer. So the DOT pieces are pretty easy because, sorry, I'm trying to turn this thing down. The DOT piece is a little bit easier because it's pretty cut and dry. But even with that, you have to remember that once it goes outside of the DOT doesn't say fire that person. They just say take them out of a safety sensitive job. So as soon as they say take it out of a safe, sensitive job, then it defaults to your non-DOT policy. So what's the rule, people? Got to have the rules. How are you going to terminate? And inconsistency is what gets you in a courtroom. So you've got to be super consistent. So when you're looking at these progressing marijuana laws, we're seeing the same thing, right? So as an example, I'm going to move myself here, but as an example, New Jersey, they have 2 that are going on. By the way, they're going to do one in conjunction with New York now. But establishes protections for medical marijuana in the workplace, makes it illegal for an employer unless able to establish a preponderance of evidence to take any adverse employment action against an employee who is registered marijuana user. Anybody tell me what that means? DOT trumps it. DOT wins. This hasn't passed yet, by the way, but these are the progressing ones. But what that means is it doesn't have anything to do with testing. That specific law says you cannot say, I'm not going to hire you or I'm going to terminate you because you are a registered user. It didn't talk about testing at all. So you'll see that in these laws, as you see progressing marijuana laws, you'll see where they say you cannot discriminate against an employee or a candidate because they are a card holder. That doesn't mean you can't test them, and if they become positive, that you can't make a negative employment action against them. So you've got to look at each of those progressing laws, and you saw how many there are. And some will fail, and some will pass, and that's marijuana. Then there's recreational marijuana. It got shot down just because Jersey's right here. Recreational legalization got shot down. It's back again. So it's likely to pass any day. You know, now Jersey, New Jersey, Pennsylvania, New York, and I think Delaware have sort of bonded together and said maybe we should go into this together to make it more simple. We're not Texas, so I live up there. Like you can work in, you know, you're right across the line, so you can work in Jersey and go back and forth to Pennsylvania. So they're sort of saying, why don't we try and make it consistent? Well, wouldn't that be lovely? Because that's part of the issue. But it's not just because of these laws progressing. You have to be aware of every way and then how you're going to interpret them. So the employer protections are the new thing, right? We've got employee and employer protections. And if you were in phase session, you've heard a lot about this. We're at the end, so we're kind of clean up here, right? But you know, they talk about what your rights are as an employer, but as we get into the next section, we're going to find that a lot of your rights, because they're written by politicians, they talk about things like impairment, and they talk about what you can and can't do and when you can test, but they're not realistic, and they, unfortunately, some of these fly in the face of other laws that are in their state. And there are states where there's actually conflicting laws. These are not the bills that are proposed. These are bills that have passed. These are laws in states where one law and a second law says something completely different. And so that's what Frank was alluding to. You've got to make some decisions, right? You've got to make some decisions about what's your level of risk tolerance and why are you testing, why is it important for you, understand the laws, and then modify your policies and your procedures based on what you believe will be best for your organization. And it can be very different, and there is a lot of gray area. However, policy written in accordance with the laws, training, you know, established, those are things that protect you. It's like wearing a bicycle helmet, right? You train every person in your workplace, and it's an added level of protection for you. And I'll tell you, I'm going to get off topic here, which is bad, but we'll talk about it a little bit. But we just provided expert testimony in a case. It was a national employer. Everybody would know their name. They had employees who drove from one site to another moving cars, not CDLs, just moving cars. For whatever reason, they chose not to test those people. We don't know why. Nor did they do any fitness for duty testing. Now, they did promotion testing and they tested in their work, like their regular employees. They just, I don't know why, they just chose not to do this. Nor did they train them. A man had a heart attack, came back to work, because that's a whole other conversation, right? But his doctor just said he didn't realize that this guy was driving these cars back and forth. So he returned the guy to duty and said, yeah, this person can go back to light duty. Unfortunately, he never saw his job description that said it's a moderate duty job, but whole other position, right? He drove the next week, he crashed into a semi, killed himself, killed another guy, and hurt 6 other people. Needless to say, they got sued. The argument from the employer was, there was nothing we could do. He may have had a heart, oh, by the way, he had THC in his system after they unfortunately cleaned the guy off the road. And so they said, well, he was high. Well, no, he wasn't. We don't know if he was high, right? We have no idea. We don't know. We know there was marijuana in the system. We don't know if he was impaired, nor do we know if he had a heart attack and you put him back to duty. But what we do know is you didn't test. You didn't do fitness for duty testing, and you didn't train anybody in your organization on signs and symptoms and reasonable cause. You didn't do randoms. And so guess what? You're liable because you're negligent, because it was a reasonable assumption that you would have done that in your workplace. So did they cause the accident? We don't know why the guy did it, right? But in the end, the employer settled for a whole bunch of money because they couldn't prove it and because they didn't take those reasonable and customary precautions in their workplace. And that's really what you're doing, risk mitigation, right? When we're looking at the future of pre-employment drug testing, if you were in an earlier session, you heard about this. We are seeing states who, again, because of political pressure and frankly, tax revenue, are passing laws, and the laws are starting to prohibit you as an employer being able to test for THC, except it's in a safety-sensitive position. And safety-sensitive positions right now in the United States are very narrowly defined. So you've got to not only look at your drug testing policy when you're trying to design this thing, you've got to look at all of your different positions and say, as an organization, which ones can we define as safety-sensitive and how can we define them as safety-sensitive? And we're going to see, hopefully, that the definition of safety-sensitive starts to expand for employers because it's antiquated. It's safety-sensitive, meaning just your physical safety. It's not cybersecurity. It's not, all of those other pieces that could be safety-sensitive. So you've got to look at your people. You've got to say, we're going to define these people as safety-sensitive, or how are we going to define them, and then start to test them. And so there are also laws that are employee protections, and these are the ones that say, without a preponderance of evidence, you may not test this person, right? New Jersey, I'm picking on New Jersey, it just keeps coming up on my screen, right? Employers must offer applicants and employees the opportunity to present a legitimate medical explanation for a positive test. So if you're in that role and you said, hey, I smoke pot, right? I got it from my guy, or my doctor. I live in Pennsylvania, and I have neuropathy in my feet, and so I do this. Are you willing to say, all right, we're going to fight you on that because we think that it's a non-FDA approved drug. There have not been clinical trials in the United States. It's a Schedule I drug. We want you to prove in a court of law that that was the only drug you could take. You couldn't have taken something else? And so all of these things have gray areas. So you gotta kind of do the, you gotta do the case studies in your own workplace. Are they gonna fight that? If they said that, what would we do? Is our policy clear, and does it state what we would do in that case, right? Are we willing to hire the lawyer to fight for this case that says, yeah, no. We as a company don't believe that marijuana was the only thing that you could have done in this case, or we don't believe that it's a legitimate medical explanation. Go ahead. That's I swear, the #1 question we've gotten year over year. There's actually no real rule. There's a case that was, I believe, Missouri. Morgan, you probably remember. It's Missouri or Minnesota that is precedence for whether it's where you live or where you work. And you can choose to use that as your basis. Even though it's in a specific state, it tends to sort of set it, but that's all you've got. So again, we would advise you that it is where the person works. But now if you look at the New York law, it's or where they live, but in New York, it's where they work. So if they're coming in from Jersey or coming in from Pennsylvania, how are you going to figure that out as an employer, right? Are you going to know where they live, where they work, where their work site is? What are you going to do with contingent employees? What are you going to do with gig employees on and off the payroll? So it gets very, very, very challenging. And so, again, you got to keep having dialogues, working with DISA, working with people, and figuring out what that policy is going to look like, because there's not necessarily clarity across the board. Progressing adjustments to state drug testing laws. These, it's so funny, we talk so much right now about marijuana and opioids, we kind of forget all the other stuff, but there are lots of states where there are things that will affect employee drug testing law that have nothing to do with opioids and nothing to do with marijuana. So California prohibits AB 882, right? An example, prohibits employers from terminating employee based on a positive drug test if the drug in question is being used as a medically assisted treatment under the care of a physician or in a licensed treatment program. Translate that, right? And so again, these progressing laws don't just have to do with marijuana and opioids, they have to do with general provisions about drug testing. When Frank mentioned today, so the SAMHSA just put in the reading room, which means tomorrow they'll publish the oral fluid mandatory guidelines. SAMHSA will do it, and then once they do, likely DOT will come and align themselves, and so it'll be available after the implementation period for DOT employers to use. Probably 18 months is the guess, right? So if that's the case, you say, all right, well, you just said, state and federal are different when it comes to drug testing law. Here's the problem. Because the states were willy-nilly when they created these laws, often they say you have to comply with SAMHSA rules, or you have to have a DOT panel, or you have to have an HHS panel. And so even though the federal law doesn't govern what those states say for non-federally regulated employers, because they reference the DOT, SAMHSA, or HHS in their laws, when that happens, those states will change as well. So that's outside of a bill. That's just because of how their laws are written. So you've got to know all of those different things. So when we talk, I'm skipping through here fast because we promised drinks. When we talk about the impact of marijuana, this is the issue, right? The issue is impairment. The issue is this is what started the gray area, right? It's Schedule I drug federally. It's both medicinal and it's recreational. There's no legal limit that's consistent in the United States. It's technically not a medicine like Tylenol where you can open the thing and find out how it's administered. And so it really covers all of these different areas. And you've got to learn how these new laws and the issue of impairment as it's addressed in these new laws, how you're going to deal with it within your workplace. And again, that's part of design and it's part of policy. So we'll go through that. This is why it's important, right? It's important because potency's increased, and again, this isn't are you pro or are you con, you've got to look at it in terms of your workplace and the cost. It's increased. This I don't believe, by the way. I got to get this out of this slide. Marijuana can be impairing for 24 hours after a single use. I'm going to just ignore that. But if they're under the influence in your workplace and they cause an accident, you are liable, right? They might not be able to sue you as an employer, but they can do a workers' comp claim. You can pay their medical benefits. And if they hurt anybody else or a customer, then you're going to pay for it. The difference between under the influence and impaired, I can't go into it in huge detail and really commit to the getting out of here on time, but basically it is, what is the difference between Nina taking 5 milligrams of oxycodone as directed by my doctor for a legitimate medical reason, or a glass of wine, or marijuana, and going into the workplace, right? So you've got to look at your policy language and make sure you've defined those different things. When I go out there and I have a glass of wine, I am under the influence of alcohol. I'm not impaired by it. Maybe I will, it depends, but I'm not impaired by it, right? If I have 3, I'm likely impaired. But the same holds true for every drug in your workplace. And because marijuana doesn't follow any of the rules, you got to kind of look at it and poke at it from all the different angles as these new laws come about. So how would you handle it? And then, again, when we talk about how you're going to design it and the testing methodologies, how are you going to prove it? So if a state says that you have to have a preponderance of evidence that someone is impaired, what are you doing in your workplace to be able to prove or to show that they're impaired? Because again, they did not call us and say, hey, wait, before we put these laws in place, do you guys have a way to show somebody's impaired? Because the answer would have been no, we don't. So again, you've got to be able to handle it. You've got to address it in your workplace. And how do you consider impairment? What does that mean for you? And then apply that to the laws. So why is it important? Again, because 14.8 million people in a study by AAA, it has nothing to do with drug testing, AAA study, reported driving within 1 hour of using marijuana. So they will come to work stoned. Let's just be honest. They will. If 14.8 million people reported driving in the past 30 days, they're gonna show up to the job, right? And one of the reasons they said they knew it was dangerous, like they know it's dangerous. 70% of them said, we know it's dangerous. They said that part of the reason they were willing is they don't think they'll get caught. So again, it isn't direct to your workplace, but it likely is the same idea, right? If they're willing to go and get behind a wheel after using marijuana an hour ago because they don't think they're going to get caught, they're probably willing to come to your work and work because they don't think you're going to catch them. And so it isn't a catching game, but it is a risk strategy that you've got to take. And marijuana just tops the list in every one of these different, I don't think there's a single job where marijuana doesn't top the list of the drug that is most tested positive. And it's just more available now. And so it's not rocket science, right? It's more available. It's legal in states. People don't understand all these issues. And so it's going to continue to go up. And as employers, if you're seeing these laws passed that are restricting your ability to test for it, you're going to end up paying for it in the end. And so you've got to really start to get active in how all of this works. So when we look at it, we know that people are concerned. I wish I could say, here's the answer. It would be lovely. Here's the answer. We don't have the answer, right? So it's sort of like everybody needs to start swimming upstream the same way and saying this is why it's important to us as employers, both in safety sensitive and not safety sensitive. Most people say we agree that we're concerned and we got to figure this out. That's why you guys are here, right? You got to figure out how you're going to deal with marijuana. Most people say they understand the importance of a policy, but when you look at the numbers, they're concerned, but they don't believe that they've got it covered, right? Drug testing, 80% of the people think they have it covered, not 100%, 80%. But when you start to creep up and you look at employees' use of medical marijuana, most people are saying we get how important it is. They just said that in the last slide, but 45% of them think they have it covered. I'm guessing most of them are not correct, by the way. But so you've got to really get the policy in place. And the piece of this that we're going to spend the most time on is innovation, right? So you've got to say, I'm no longer going to just say, this is what we do and this is how we do it. If you do that, we just talked to somebody in one of the breakout sessions and they said, we have a blanket policy for non-DOT. It applies everywhere. I'm like, yeah, no, can't do that. Can't do that, right? You've got to go in, you've got to have a policy, and then you've got to look at every single state. And DISA does it. DISA does it every day, right? But you've got to go in. If you haven't had that policy reviewed, you are likely out of compliance. Because you've got to look and say, as all of these new laws passed, unless you've got no other job like me, I got no other job. This is all we do. We watch those 480 laws and we see what's going to happen and we let people know about we let people know about all of them, but you've got to go in your workplace, and unless you're just sitting there listening to all of these people debate in your state the applicable laws, by the way, multiple states if you're a multi-state employer, then you've got to have a way. So you've got to look and make sure that each of your states and all of the law types, the voluntary versus the mandatory, are addressed in your policy. And sometimes you can have a policy, right? If you're in 50 states, it doesn't mean you have to have 50 state amendments. You can have a policy, and then you'll say, hey, we don't do the discount laws, we don't care, but we want to do the denial laws. So we'd say, all right, well, you need 30 state addendums. And again, they are blue sky. Some are about your policy. Some are about you have to notify somebody in writing if they have a positive drug test within 3 days, right? You have to notify somebody in writing about every drug test, no matter what, negative or positive. That's what some of the states say. It's not about the test. Others are saying, you have to use a certified collector. So across the board, you have to use an MRO. Some things are best practice. It's always best practice to use an MRO across the board. My opinion, if you're doing incident testing, it is always best practice to confirm it before you take any negative employment action across the board. Use the convenience of an instant test, but confirm it. And why is it best practice? It's best practice because it's what we've seen over all these years that people get sued the most about, right? So you got to look at the federal laws, you've got to look, or the federal regulations, you've got to look at the state laws. You have to look at how the state laws then apply to any federal regulation, if they happen to in their laws. Then you have to look at your safety-sensitive positions, and you have to also consider fitness for duty, right? So it isn't just about, is this person safety sensitive, so I'm going to drug test them. As you move towards this sort of new world, you want to think, are they fit to do this job? And there are drug disclosure policies that you can also put in place, and they're more sophisticated than a run-of-the-mill policy. But they're, again, an added layer of protection that says, if somebody is performing a safety-sensitive job, we're going to do fitness for duty testing over and above just a drug test, but we're also going to require them to disclose to us if they're taking an impairing substance. And then guess what that does, people? Takes you back to that definition of impairment and how you're going to use it and how's it going to cost and what are you going to do in the policy. So you really have to look at the whole thing in a very, very broad way. And then you got to consider all that, right? What's your drug testing panel? There's no one size fits all. If you're in an area, if you have healthcare providers, right, you may want a broader panel. But what people don't realize is they say, this is what we're going to do. We're going to run a 9-panel. We're going to do pre-employment, post-accident, reasonable suspicion. You can get super creative, and that's really what I'm challenging you to do. Think about your workplace and get creative, right? So you might say, for everybody who has pharmacy access or who's providing home health care, we're going to do all of the standard stuff, but we're going to do 50% of them random, and of those, and then we're going to do a MedPro panel because they have high access to impairing drugs. And that's okay, as long as it's not, I'm going to test all of the 22-year-olds after a football game on a Monday morning. I guess maybe you could, no, that's age discrimination. It can't be discriminatory, right? But otherwise, as long as it's based on a job description, a valid reason, then you can do that within your policy, and that's really what you should think about doing. And as you move into these safety-sensitive roles, I also encourage you strongly to have a relationship with an occupational health doctor, because again, it's that whole, we don't really want to know all of your pertinent medical information. We want to have that little wall, and that's what an occ health doctor and a relationship with that. And that's, again, not the same as an MRO. That's not their job. So you got to look at why you test, right? Is it for safety? Is it risk? Is it because you're regulated for a certain group? And then you have to sort of position that against all the different reasons for test. So are we going to do pre-employment across the board? Are we going to do post-access testing to our workplace? Are we going to do random post-access testing? There's a whole variety, and it really just shouldn't be a one-size-fits-all any longer. And then you've got to determine, who are you going to test? When are you going to test them? How are you going to test them? How often are you going to test them? Then you've got to look at, under what circumstances? Are we required to test them? Or, are we just choosing to test them? And you've got to have that logic, right? Logic, rhyme, and reason. Options for testing, what drugs are you going to do? The illegal drugs are actually pretty easy, right? You can have a no tolerance policy on those. There's no legitimate reason for a human being to have PCP in his or her system, period. Those are easy, but then you've got to make decisions about the other ones, right? Does it make sense? Talk to your account rep and say to them, like, you don't have to tell me the data that you can get in aggregate is very, very beneficial when you're looking at this. So are we seeing a lot of reversals of prescription drugs in our panel? Do we want to expand the panel? Do we not want to? If we're seeing a ton of reversals, do we have a problem here with opioids? And so do we need to do this drug disclosure program instead, right? It doesn't mean somebody's not catching it, just means you've got to really be thinking about what all those numbers mean and then how to apply it and modify your workplace drug testing policies. Drug testing methodology applies too, right? You don't have to say we're just going to do a 5-panel, which isn't really a 5-panel anymore, but we're going to do a 5-panel urine for everybody for every reason, no matter what. You can look at where is instant testing or rapid response testing going to be more beneficial for us? Where is a shorter window of detection from oral fluid going to be more beneficial to us versus, and you can do that too. In California, we do something different than we do for employees in Texas. You can do that. You just have to have the right rhyme and reason. You also have to look at the new technologies that are coming out, because we still don't have a real way to identify impairment, but there are new technologies that are coming out that do. So you've got to look at that, you've got to track it, and then as appropriate, integrate those things into your policy, because those are going to be the ones that get challenged right now, because again, lawmakers are making the choice to introduce laws that introduce impairment, and we don't know how to address it yet. Policy, Frank, I'm going to turn over to you at some point. Our numbers are off, so I'm not 100%. So you just raise your hand when it's your turn. These are I'm not going to go through these in detail, but super consistent, right? You've got to have a purpose statement. You've got to have testing circumstances. You've got to say what's prohibited and what you're going to do, right? What you're going to do. And what you do is got to be consistent. It has to have rhyme and it has to have reason. Strongly talk about return to work, right? Return to work. Recovery supportive workplace, meaning will you bring somebody back, especially in this, right now there's such low unemployment, right? So are you going to lose all of that training and all of that experience, or are you going to look at doing follow-up testing because somebody has returned to duty after they failed once? Well, you could do that, but are you going to do that for the guy who's in a high-end safety-sensitive job? Maybe not. So again, you've got to look at that recovery supportive workplace, return to duty, follow-up testing. You should be thinking about all that post-hire testing and how it protects you as an employer. And then, like we said, training, first of all, it gives you a million set of eyes, right? But it also proves when you're in that courtroom, we're doing our best, right? We follow the laws, we update our policy, we train our people, we look. We weren't negligent. It was an accident, but we did everything we could to make sure. We do random testing, we do post-accident testing. We did everything we could. We weren't negligent. It may have happened, and we may have some liability in that, but we certainly weren't negligent because we did these. And these are easy things to do. And then implement them, right? You've got to be able to go to all of your key stakeholders in your organization and really talk to them. What drugs, why we're testing, and how we're going to implement it across the board and train that whole group. And by the way, just in case you thought this was just a nice to have, most states actually say that you have to give the people a policy and you have to give them 30 days before you're going to implement it. So your implementation strategy as you change it is going to be important as well. You got to look at that when you're doing it. And then it has to be clearly written. And so again, I'm not a lawyer. It gets awfully hard. When you read the legalese, when I read some of these laws, and I've read them all this time, I read them, I'm like, oh, what did that say again? Like, this is nonsense. Make it easy. Make your policy easy. You don't have to disclose everything, right? You don't have to list every individual drug that you might test for. You can leave it broad in some of those ways so that you can introduce things without having to rewrite the policy, but you do want to be clear English so that somebody can come back and really have examples, right? When you're doing those types of trainings with your supervisors and your employees, have real life examples, because again, that's the way. If I had sat up here and just read to you all these different laws, you'd be like, I don't understand anything that lady said. You want to come out and say, I made it easy to understand. You want to do the same thing for your employees and supervisors. Make it easy to understand what's going to happen. And with that, I'm turning it over to Frank. And then we can ask questions. I'll stay up here in case we have more questions.
All right, thank you, Nina. Guys, I'll tell you, it's, and I hate to admit this, it's been over almost 25 years since I graduated from law school. And having the experience of course, doing a lot of Title VII, also having the experience of, for years, double-digit years, I hate to admit, of being a corporate executive at this large retailer I will remain nameless with a big spark, spending over a decade there. This is probably, in terms of my experience, the most complex and fluid situation that I believe I've ever seen and I've ever faced. And so when I think about the complexities and the fluidity of it, I can only imagine, you know, your thoughts, your concerns, and the things that keep you up at night. Well, we're here. We're here to help you. We're not just a company that does drug testing. We support you as it relates to your compliance and helping you draft those appropriate policies. And so when you think about those appropriate policies, you know, we have custom policies for you. will help you on an individualized basis develop those for all modes of DOT and as well as different states and territories. We've got the forms that can assist you, and most importantly, we can help you with your training, and in some cases provide audit support for you. And as I made a commitment to Colin to ensure I get you out on time, I want you to just understand and know that we have a process or a methodology. We're going to help you apply that particular methodology to be successful. Please don't hesitate to reach out to myself or any individual with a DISA badge, and we will move you, so to speak, to the front of the line to help you draft and find the best policies that fit your organizational needs. With that being said, sincerely, I'd like to thank you for allowing us the opportunity to talk about policies with you today, and we look forward to speaking with you individually as we close out this particular session, and we allow you to get to your beverage of choice. Please feel free to come to the front of the room if you'd like to have dialogue with Nina or I. Thanks a lot, and it's been wonderful having you.